What's going on, y'all? Attorney Tom here. It's time for another USCSB React. In today's video, we are going to be reacting to the video titled No Escape, Dangers of Confined Spaces. As many of y'all know, in the real world, I'm a catastrophic personal injury lawyer located in Texas. And it just so happens that, unfortunately, a lot of the cases that I deal with have to do with refinery explosions, adverse chemical reactions, things that the USCSB generally covers. So make sure you stick around to the end of the video where I'm going to give my determination of fault. All right, y'all, let's jump into it.
October 2nd, 2007. A terrible tragedy unfolded in the mountains 40 miles west of Denver, Colorado. 5 contract painters were trapped by a chemical fire deep inside a hydroelectric plant tunnel. The plant was owned by Xcel Energy, a major regional electric power company. The fire, involving combustible coatings and solvents inside the tunnel, blocked the only way out, an opening more than 1,400 feet away.
Okay, so right off the bat, we're told some very important information. One, they were contractors. They did not work for Xcel. So these were contract painters. They were not employees of Xcel, which means that the full course and scope of legal remedies is probably available to them. If you're an employee of a company and you get hurt, depending on what state you're in, you might be barred from pursuing legal action because you might have to go through workers' compensation. The second issue that we've identified is that the paint is apparently what caught on fire, or the coating, whatever they were applying. So I want to know, was it the coating's fault? Was the coating being used for its purpose? Were there any safer designs for the coating? Meaning, could the manufacturer of the paint or coating or whatever it was have produced a similar quality that maybe isn't flammable? Next, I want to know why they had so much coating inside of the tunnel. Because let's just say that there was no getting around. It has to be flammable. This is just the product the way it is. Well, why did they put so much in the tunnel at one time? It seems like there was a fairly large reservoir. You know, maybe you take one bucket in at a time. Next, there's only one way in and out of the tunnel. That is generally not a good idea. So if you have to work in a confined space that only has one way in or one way out, you're probably going to need some form of escape plan or firefighters on standby.
There was no help available because the company did not have properly trained emergency responders standing by.
Jeez, hire me. USCSB, let's collab, even though you're supposed to be a neutral governmental agency and I'm, a very biased plaintiff's lawyer. Dude, come on. Look, I'm prepared for this job. You know it.
For such a rescue. For the workers, there was no escape. The Chemical Safety Board found that neither Xcel Energy nor its contractor, RPI Coating, had adequately evaluated the dangers of the work inside the tunnel.
The RPI contractors entered a confined space with highly flammable solvents, little training, and no emergency plan.
Okay, it says that they had little training. So these were contractors. They were brought in specifically to do this job, meaning that even though they were contractors in the sense that they didn't work for Xcel, their company, RPI, should train their employees. So we would look at the training of their employees, why they weren't adequately trained, what kind of training was available to them, things like that. That argument can extend to Xcel as well. Why did you allow such untrained individuals to work on this project? You should have done your due diligence and hired somebody who knew what they were doing.
From the moment they entered the tunnel, the stage was set for disaster.
Xcel Energy's Cabin Creek hydroelectric plant is located in a remote mountainous area approximately 6 miles from Georgetown, Colorado. A 4,000-foot tunnel, known in the industry as a penstock, was slightly inclined at the bottom and extremely steep at the top. The penstock carried water between the upper and lower reservoirs. At the bottom, water flowed through large turbines to generate electricity. Over the years, the penstock lining deteriorated. In 2007, Xcel Energy contracted with RPI, an industrial painting company, to recoat a large steel section of the penstock near the power plant and lower reservoir. Work began at the site in September. The penstock is a unique confined space that is difficult to enter and exit. Before the project began, a door was cut into the lower section to provide access for workers and their equipment. On the morning of the accident, October 2nd, RPI workers prepared to begin the coating operation by bringing approximately 10 gallons of a highly flammable solvent called methyl ethyl ketone, or MEK, into the penstock. Some of the solvent was used to clean the equipment and hoses before starting the work. Shortly after 1 p.m., 11 workers began coating a section of wall located more than 1,400 feet inside the penstock. To apply the new two-part epoxy coating, workers used a specialized sprayer. Base and hardener were mixed and then sprayed onto the walls. But the workers immediately encountered problems. The epoxy was not adhering evenly to the surface. The workers flushed the hoses and spray wands with MEK each time a problem arose. But despite their efforts, they could not get the epoxy to adhere evenly.
Okay, so now we're getting some information as to whether or not maybe we can make a product's defect claim. Generally, there are 3 broad categories of product defect, and these are very broad because there are literally thousands of subcategories. But a defective product, defective design, and a failure to warn. So for something to fall into the defective product category, that one particular product needs to be defective. Meaning, let's just say you publish 1,000 widgets and that one, only that one, was messed up in how it was produced. It was defective. Well, that's a product defect. A design defect would be all 1,000 widgets that were produced were defective just because it was a negligent design. And for that, you're going to look at safer alternatives. Were there any safer alternatives available to the manufacturers at that time? And third, failure to warn is exactly what it sounds like. Did you adequately warn that your product was dangerous and shouldn't be used for the reason why it caused the injury? So applied here, I want to know what MEK is. Did they need to apply MEK? Was there a non-flammable solution that they could have used? Additionally, why wasn't it adhering? Was the mixing tank messing up? Why did it mess up? Why did the mixing tank mess up? Why did they even have to mix it inside the tunnel? Could they have mixed it outside of the tunnel? Things like that.
An RPI foreman decided to clean and remove the sprayer from the penstock. The crew began cleaning out all of the equipment and hoses using MEK. A worker brought in more of the flammable solvent to aid in the cleaning. Some workers noticed the strong odor of MEK as the vapor spread through the work area. At approximately 2 p.m., the vapor was ignited, most likely by static electricity inside one of the spraying machine hoppers. A flash.
Okay, so the spark was ignited by static electricity, most likely in one of the spraying machine hoppers. Was the spray hopper designed in such a way that it was supposed to deter static electricity? After all, it is foreseeable that static electricity is going to be an issue in these type of events, and it's foreseeable that the things that they are mixing might be flammable. So if you're designing a spray hopper, you might need to design it in a way where it deters static electricity or mitigates it at the very least.
Fire erupted. Burning solvent burst from the hopper onto a nearby worker, catching his sleeve on fire. The flames spread quickly, engulfing the open buckets of MEK nearby.
Next issue, why were there so many buckets of MEK inside? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 buckets. So again, maybe if you're mixing a flammable solution, you don't bring it all in at once. Maybe you bring in 2 buckets max at any one time. It's a total pain in the ass because you got to go back and forth. But if it catches on fire, it's probably a preventable fire or a fire you can extinguish.
Engulfing the open buckets of MEK nearby. 5 workers were blocked from escaping the penstock by the intense fire. The trapped men shouted desperately for fire extinguishers, but there were none inside the penstock. Workers on the other side of the burning equipment ran the 1,400 feet to the entrance to locate fire extinguishers. One worker notified the control room operator to call 911. The 5 trapped workers could do nothing but wait and hope. Inside the penstock, the nearby buckets of epoxy and MEK burst into flames. The trapped men fled deeper into the penstock to escape the smoke. They used their radios to communicate with the workers outside, imploring them for help. Workers repeatedly attempted to fight the fire with portable extinguishers, but they were forced to turn back by the intense heat and thick black smoke.
Would they have been able to fight the fire if the fire extinguishers had been readily available? Meaning, if immediately after the fire sparked, if they had fire extinguishers right next to them or available to them, could they have extinguished it or at least done enough to clear a path for the other individuals? Another issue.
Inside the penstock, the workers continued to wait for rescue. At 2:11 p.m., county emergency personnel arrived at the site in response to the 911 call. But they had not been informed about the hazardous conditions within the penstock, and they were not equipped or trained to attempt such a technically demanding rescue. The trapped workers were instructed to move even deeper into the mountain, but they stopped when they reached the inclined section, which was too steep to climb. They told responders they were struggling to breathe as smoke filled the penstock. Some of the responders entered the penstock on an all-terrain vehicle, but the dense smoke blocked their path, and they had to retreat after just 200 feet. The responders then drove up the winding road that rose over 1,000 feet to the upper reservoir. There, they lowered air bottles and respirators through a small hatch, hoping these would reach the trapped workers below. Finally, at 3:40 p.m., a specialized rescue unit arrived from Denver, some 40 miles to the east. A short time later, a specialized mine rescue unit arrived. The teams prepared for entry, but it was too late. The 5 workers inside the penstock had died of smoke inhalation over an hour earlier. The following day, responders found their bodies near the bottles of air.
So a couple more issues that I saw. So first, the fire department came. The first batch of fire department arrivals were unequipped to perform such a technically demanding rescue. So what might happen is the premises owner or the contractor might say, listen, yeah, we messed up, but it's not our fault they died. If the fire department would have been properly equipped or trained, they would have been able to save them and they would have been alive today. So it's really the fire department's fault. That argument is not going to fly. Generally speaking, in order to absolve somebody of any liability in a negligence action, you're going to need an intervening superseding event to break the causal chain. Basically, you're going to look for something that is an act of God or something that is so unforeseeable that you can't hold the primary actor responsible. Here, a fire department coming that is unequipped for a highly technical chemical rescue, that is not intervening, superseding by any means. That is foreseeable that they're not going to have that capability immediately. So that argument just is not going to fly straight from the get-go. Next thing I want to talk about is this was a brutal time from 2 o'clock to 2:45 when these guys died. They were trapped. They knew they were trapped. They were struggling to breathe. It was a slow demise. Can you imagine that 45 minutes? You know that there's very little hope. You feel your life just draining from you because it's getting harder and harder to breathe. As a lawyer, when you're bringing these actions, this will be part of the survival actions, meaning you're going to sue for the pain and suffering, mental anguish that they suffered while they were alive. What is that 45 minutes worth? On top of them dying, which is going to be the wrongful death action, but the survival action is what is this 45 minutes worth? In 45 minutes, knowing that you're probably gonna die. You're thinking of your family. You're thinking that you're trapped. It's getting hotter and hotter and harder and harder to breathe. I mean, that's substantial.
The lack of regulatory limits for bringing flammable materials into permit-required confined space.
Okay, so this is very interesting. The lack of regulatory limits for bringing flammable materials into permit-required spaces. So, like I was saying earlier, why did they have 17 gallons of MEK inside the tunnel at once? I thought maybe that was probably against some sort of safety guidelines. That doesn't appear to be the case. It says there was a lack of regulatory limits for bringing flammable materials into this space, meaning their actions did not break any sort of permit requirement, any sort of regulation. Now, that doesn't necessarily mean that they weren't negligent. You have to think for yourself. You have to use common sense. Just because something isn't expressly against the law doesn't mean that it's not negligent.
Xcel Energy's flawed process for contractor selection and oversight, and the lack of preparation for possible emergency.
Okay, Xcel Energy's flawed process for contractor selection and oversight. Exactly what I said. Why didn't they pick somebody who was trained to do this? Okay, so now that we've talked about the issues, let's talk about the parties and assign a percentage of fault. So there are three main parties here. One is Xcel, two is the contractor, and three is the potential manufacturer of the MEK and or the spray terminal, the spray widget that sparked. So unfortunately, we are just not given enough information about the spray terminal, the spray widget, why it sparked. So I'm not even gonna go there with respect to trying to make a product's liability argument. So really, we need to assign the fault between Xcel and the contractor. And in my opinion, if you are the premises owner, you have a duty to keep your premises secure. You know your premises better than anybody. You know what these individuals were doing was dangerous. You knew there's only one way in, one way out. You knew that they were probably going to be using some form of chemical that was probably flammable. So you need to take precautions. You need to have emergency crews there, and you need to vet the out of your workers or your contractors, and they didn't. So yes, I definitely think there is some fault on the contractor for sending untrained people there, but I would definitely say 70 to 80% of the fault on Xcel, 20 to 30% of the fault on contractor. That's how I see it, at least if I was the lawyer. All right, talk to y'all later. Bye.
He's a catastrophic injury attorney who accidentally became a YouTuber. Attorney Talk.